There's some other circumstances where they would be able to use that testimony, but the most important thing is it would be your choice, and any testimony that you would be able to provide at such a hearing could not be used against you for the ultimate decision of guilt. You understand that?
Yes.
And with me explaining all of those rights, you understand them and you have no further questions in regards to that, correct?
Correct.
Your Honor, I believe that I satisfactorily covered all of his constitutional rights, if in fact he did choose to proceed to a full-blown hearing today, Your Honor.
Okay, thank you, Mr. Maddie. And Mr. Hertgen, your attorney has explained the rights to you. You have indicated that you understand those rights. Do you need any additional time to speak with your attorney about the detention hearing or your rights at the detention hearing?
No.
Okay, thank you. And Mr. Maddie, will you please continue with voir direing him regarding the knowing and voluntary nature?
Of course, Your Honor. So, Matthew, at this point, the questions that I will ask you are dealing with our choice to consent to detention, okay? All right. So, as we previously discussed, myself and Dominic have met on numerous occasions, and we have talked about this legal case, correct?
Correct.
And during these meetings, we discussed various legal options that you would have the ability to choose on whether to have a hearing or consent, correct? So after all of these meetings, and with the advice of counsel, at this time, you are electing to choose to consent to detention, correct?
Yes.
Now, you were doing that with the advice of counsel and voluntarily, correct?
Yes.
And you're also doing that intelligently based upon my legal advice and making an informed decision, correct?
Yes.
And at no time did I, co-counsel, or any other individual coerce you into making this decision, correct?
Yes.
So what I hear you saying today is that after communicating with me, providing you with sound legal advice, it is your option at this point to elect voluntarily, intelligently, and without coercion to consent to detention, correct?
Correct.
Now, just because you consent today, that does not mean that we cannot come back to court at a later period of time and withdraw our consent and ask this court to have a full-blown detention hearing. I explained that to you, correct? So just because you consent today, you understand that we have the absolute right to withdraw that consent at any point, and I would notify Judge Wilson, and then we can come back to court to argue the merits of this detention hearing, correct?
Okay.
Okay. Now, Your Honor, I believe that that is a satisfactory basis for the court to consider that this has been done voluntarily, intelligently, with the advice of counsel. I would now get into his appellate rights if you want me to.
Okay, after I ask him a couple of supplemental questions, Mr. Hertgen, now that you've indicated that you are knowingly and voluntarily waiving your rights, I just want you to be clear that the court is prepared today to proceed with the detention hearing. You are not required to consent. I want to confirm on the record that you are consenting without any force, threat, or coercion from anyone. So are you waiving your rights to the hearing and consenting to detention voluntarily?
Yes, I am.
Okay, thank you, sir. Okay, so given that the defendant has been advised of his rights and that he would have at this detention hearing, and he has indicated that he understands those rights, as well as that he is consenting to detention both knowingly and voluntarily, the court will grant the pretrial detention. And at this time, I'll ask defense counsel to voir dire his client with respect to his appellate rights.
Well, thank you, Your Honor. Matthew, it is somewhat strange because you consented, but you have the absolute right. Just because you consented, you do not give up your right to appeal. Do you understand that? And because, I'll explain it this way. If we had a hearing, because these hearings are done quickly, the appellate division expedites that process. So what I mean by that is, since you consented today, you would have a 7-day period to file an appeal. Do you understand that?
Yes.
And that you have the absolute right from today or any time within the next 7 days to speak with me and to evaluate whether or not you choose to appeal this consent. Do you understand that?
Yes.
And that part of that process would that we could obtain transcripts of what transpired today to help felicitate the appeal. You are represented by the public defender's office, so of course we would pay for that. Do you understand that?
Yes.
Now, just because I represent you, that you could always choose to hire a private attorney to then assert your appellate rights. But as we speak today, I am your attorney, and that if you did choose, we would confer and we would file that appeal. Do you understand that? The only other issue is that because it is done quickly, if we do choose that after legally talking about it, I would file that on your behalf. All of the rights I've explained to you about your right to appeal, your consent today, you fully understand and acknowledge and have no further questions, correct?
Correct.
Your Honor, I believe that my client adequately understands his appellate rights. And of course, if at any time he needs a further explanation, I will immediately discuss that option with him.
Okay, thank you. Mr. Hertgen, and your attorney indicated that appeals from detention orders are expedited within 7 days. If you miss that 7-day deadline to file your appeal electronically, you may lose your right to appeal this court's order of detention. So in that case, you or your attorney should nonetheless apply to the appellate division for an extension of time to file that appeal if you need additional time to do so. Again, you'll confer with Mr. Maddie and he will provide you with guidance on that. The other point is that, sir, you are advised that you will be held in pretrial detention pending the disposition of the appeal. Do you understand that?
Yes.
Okay, sir. So now that your attorney has provided you with those rights, do you have any additional questions regarding the detention hearing, regarding your appeal that you need to take time and speak with your attorney about, sir?
No.
Okay, thank you. Anything further from the state at this point?
I believe the defendant has provided an adequate factual basis with regards to his consent as well as his appellate rights, and the state satisfied at this time.
Okay, thank you, Mr. McCann. And Mr. Maddie, what judge will this matter be assigned to?
Your Honor, we request that the trial judge be appointed Judge Lytle. And as Your Honor, we had an off-the-record conversation prior to today's court proceeding. And because of some conflicts and a vacation, that I have elected that the next date before Judge Lytle be March 24th. And could I request a ready hold for 1:30? Because Your Honor is well aware our detention calendar every day is packed. So it would give me, I would ask for that appreciation if we could list it before Judge Lytle at 1:30.
Okay, thank you. Any objection from the state?
No, Your Honor, the state will be available at everyone's convenience.
Okay, thank you. So this matter will be listed with Judge Lytle for March 24th, 2025 at 1:30 p.m. Okay, anything further from the state?
No, Your Honor.
Thank you. Anything further from the defense?
No, Your Honor, and thank you. And I'll see you later.
Okay, thank you. Okay, thank you. That concludes this matter.